Okay, we're on the air. Good evening, ladies and gentlemen. I'd like to welcome you to the special meeting of the Development Commission for June 5, 2019, to discuss have a public hearing on the Issaquah Highlands Retail Site Development Permit, the Issaquah Highlands Medical Office Administrative Site Development Permit, and the Issaquah Highlands Self-Storage Administrative Site Development Permit. We have one issue that we need to take care of, and that's approval of minutes. Are there any objections to approving the minutes of the May 30, 2019, May 30, 2019?
No.
No. Then by unanimous consent, the minutes are approved. When we last met, Ms. Carey was finishing her rebuttal, I think, with Patrick Mullaney.
That's correct.
And I'll turn the time over to you.
Thank you. And we've completed our directive, Mr. Mullaney, so I think it's now time for his cross-examination.
Okay, I appreciate the...
Mr. Mullaney, could you come back to the stand for just a few minutes? Mr. Mullaney, can you please verify that you continue to be under oath?
Yes.
Referring back to your rebuttal testimony, I believe that you had testified that you had expressed disappointment that city staff had apparently been engaging in your words, behind-the-scenes communication and assistance with respect to other applicants that was not extended to IHIFC. Do you recall that testimony?
Yes.
Could you please describe what specific instances you're referring to in regards to that behind-the-scenes assistance?
Well, I was referring to, I believe in my testimony, two things. Number one, in the November 21st email exchange between Director Niven and Ms. Heim, where he confirmed that shelters pre-application, complete pre-applications, land use permit applications were vested to the development agreement. I mentioned that after this litigation started, we later saw an addition to that email correspondence that was between Mr. Niven and Ms. Sloman that put caveats on the vesting that were not relayed to shelter at the time.
And could you describe those caveats, please?
If you could tell me what the exhibit number is, I could just read what he said there.
Well, I believe you were referring in your original testimony to Exhibit S4. Are you referring to something else in your comments tonight?
Yes, so I'm looking now at Exhibit S4, and the email exchange between Director Niven and Ms. Heim, there were 3 emails, and the last, the exchange that occurred between them essentially was, Ms. Heim said, "Thanks, Keith. We have not received any requests for additional info. I'm assuming that you mean that the applications are complete and vested to the development agreement, as stated in the email below, and as we discussed in our meeting with you today. Please confirm." And Director Niven responded, "Yes." So then, and again, we didn't see these emails until after this litigation was commenced. The following day, November 22nd, 2017, at 9:29 a.m., Ms. Sloman wrote to Director Niven and said, "They aren't vested unless the council agrees to the vesting language. I'm confused." And Director Niven wrote back to her and said, "They are vested at this moment under the DA. If the council removes the proposed vesting language, they will lose their vested status." And then Ms. Sloman says, "Shouldn't that be clear in the response?" So that's what I was talking about.
Okay. Do you recall your testimony concerning the...
Excuse me. Also, I was talking about the situation with Mr. Haas and the City Surf application.
And that, I think, is really the focus of my question to you tonight, Mr. Mullaney. You had alluded to the city's communications with Mr. Haas as, I believe, and I'm paraphrasing, an indication of the city's intent and attempt to facilitate Mr. Haas's development proposal. Is that an accurate assessment?
That's correct.
Okay. Are you aware of any other instance in which the city, in your view, attempted behind the scenes to assist some other applicant, but not IHIFC, as the development agreements were winding down?
Yes.
Could you please elaborate on that?
Yes, I believe that Sarah Hui, who was the, I don't know exactly what her title was, but she was involved with the Issaquah Highlands Owner Association, and they were seeking to do a development, and I believe Ms. Sloman directed her to seek a short plat of her property that would otherwise have been unnecessary in order to ensure that that development would vest against the changes in the regulations. And that advice was given several months before the language that changed the vesting was made public.
So several months before the language that changed the vesting, and is that in reference to the staff recommended vesting language for the replacement regulations?
I believe that occurred, I want to say it was February 8th, 2018, yes.
And that communication that you just referred to occurred several months before that?
Yes, and again, we weren't made aware of this, any of this, until the litigation started, and we obtained those emails through a Public Records Act request.
So the several months, I'm assuming that that would refer to something that transpired in September or earlier? How would you define several?
Without having the documents in front of the email, I don't recall the exact date, but it was certainly before January. It was in 2017.
Okay, thank you. Do you recall your testimony on rebuttal concerning the, and again, I'm paraphrasing here for the lack of a time to review the transcript in any depth, the effect that the city did not, to your view, deviate, at least publicly, from Mr. Niven's yes email in November 22nd, 2017?
Could you rephrase that? I'm
Sure.
sorry.
Do you recall your testimony concerning the November 22nd, 2017 email from Mr. Niven to Ms. Heim?
Yes.
Okay. And I believe, and again, I'm paraphrasing, that you characterized your disappointment or surprise that, in your view, the city had not publicly corrected that statement, at least in the near term following that email exchange. Do you recall that testimony?
Yes.
Okay. Could you please refer to Exhibit C7? And specifically the memorandum contained on pages 2 and 3 of that exhibit. Could you please look at the chart or the table titled Table Listing All Pending Permits on page 3 of that exhibit? And
Yes.
specifically the far right column entitled Vested by Proposed Language?
Yes.
Okay. How do you construe the text that is set forth there?
So if you look on page 1, paragraph 2, second sentence of that paragraph says, or actually I'll read the whole paragraph. By way of introduction, some pending permits are or could be vested by state law, preliminary plat, short plat, development agreements, building permit. At a minimum, these would have to be submitted and deemed completed prior to the replacement regulations going into effect. So was our understanding is that permits were submitted under the development agreement that were deemed complete prior to the regulations going into effect were vested.
But the column that I referred you to on page 3 specifically indicates that, does it not, that the applications that Shelter had filed were, quote, vested proposed language.
Yes, and at the time that this memo was written was at the same time that Director Nivens wrote his memo and made his presentation to Land and Shore, where he said that the staff recommended proposed language vested permits under the development agreement that had complete applications, and that in particular SDP permits would be vested for a term of 3 years after those permits were issued. So this, where it says this here, at the time this was said, it was absolutely consistent with West Main and our understanding of vesting law.
Did you testify or otherwise address the City Council's Land and Shore Committee at that meeting?
I did.
And did that meeting occur in December of 2017?
I can't say for sure. I believe it was early to say. It was. I went to several meetings and I testified more than once on vesting. So there was one, I believe, in November. I want to say it was November 21st, and I believe there was another one December 8th. I can't recall. There were also meetings at Land and Shore and in front of the council. So without having some chronology in front of me, I'm not exactly sure which was which, but I did testify on vesting around that time.
But you would agree, wouldn't you, Mr. Mullaney, that your testimony to the council occurred after the November 22nd, 2017 email colloquy between Mr. Niven and Ms. Sloman, correct?
I can't say for sure when I can't say what meeting was Land and Shore and what was council. And I think that I testified on November 21st. I think there was a meeting that night, and then I also think there was one later, but I'm not sure.
At those meetings, or at one of those meetings, Mr. Mullaney, was there another attorney who provided argument to the City Council or the Land and Shore Committee that was contrary to your position on vesting?
Mr. Rich Hill came. He was representing the owner of the retail establishment across the street, and they were trying to block any development of Shelter's property that would include a retail component, yes.
Did Mr. Hill's argument and position regarding the West Main issue comport with yours, or was it different?
It was different.
Okay. Could you describe the difference?
It was wrong.
Did Mr. Hill have some personal familiarity with the West Main case?
He was one of the attorneys when he was at Foster Pepper who had argued the case.
And his position as expressed to the City Council was different than yours?
That's correct.
Thank you. Do you recall your testimony regarding the alleged vesting of pre-application materials under the development agreement?
Yes.
Okay. To your understanding, Mr. Mullaney, does the 1996 Issaquah Highlands Development Agreement contain a provision that specifically purports to vest a pre-application submittal?
My understanding of the development agreement is that the definitions in Section 6 speak in terms of implementing approvals. And sometimes it talks about implementing approvals, and in other places, it talks, I believe in 3.23, about applications for implementing approvals. And so that's my understanding of the terms that were used in the development agreement.
Okay. Does the agreement, to your knowledge, use the term pre-application in any context?
Yes.
Does it use it in the term, in the context of defining any vested rights or vesting protection for a pre-application submittal?
So my understanding of the use of the term is in Appendix L, on the chart on page 3 of Appendix L, it speaks of the possibility of an optional pre-application meeting. The issue was what the city considered an application for an implementing approval, and which is why I discussed that, or I sent that, it was an email that I sent, but it could have been a letter to Director Niven in the early part of December, and that was one where he said he would send it to Mr. Haney and let us know. And the reason was I wanted to confirm that, because there was different terminology being used, that the vesting that he had confirmed Shelter had obtained with its pre-applications applied to the implementing approvals under the development agreement. And so he said if there was a problem with any of that, or words to that effect, that, he'd send it on to Mr. Haney, and if there was any issue with that, he'd let us know, and we never heard back.
Mr. Mullaney, did you construe Mr. Niven's November 22nd, 2017 email as a final appealable decision?
No, I did not construe it as a final appealable decision. I just construed it as confirming that we were vested.
I'd like to introduce a new exhibit. This is, I believe, C66. After you've had a chance to review that document, Mr. Mullaney, could you please describe it and identify it for the record?
So this is a January 10th, 2018 email from Ms. Sloman to Director Niven and myself.
Okay. Could you please describe the content and context of that email?
I believe that, I'm just going off memory here, so, but I believe that the context was that Shelter had received rejections of its applications based on the fact that the preliminary plat that it had applied for had not been approved yet by the city.
Was this email communication between yourself and Ms. Sloman and Mr. Niven, something that ultimately culminated in the March 15th, 2018 letter agreement that you testified to?
It had something to do with it, yes. I mean, it was an explanation. Take a step back, I couldn't understand, and I frankly still can't understand why a preliminary plat had to be finalized or a final plat had to be recorded before the city could accept an application for a site development permit. Because in my mind, there are application criteria that are set out in the city code, and if you meet the application criteria by submitting the materials that have been requested, it should be a ministerial decision to deem the permit complete. And so the whole, what these things seem to be doing in my mind are talking about the city's review, for instance, concerns about property lines or easements or roads. That has to do with whether or not the permit should ultimately issue, not whether or not a complete application has been submitted. So given that we were at an impasse and we had gotten 9 rejection letters, most of which were based on this idea that somehow you had to have some final action on a plat, the idea was, well, how can we work around that? And so that's what this email is part of.
Okay, and I respectfully direct your attention to the first bullet point of Ms. Sloman's January 10th, 2018 response to yourself and Mr. Niven. Could you please read that aloud?
The one that starts the plat?
Yes, please.
Plat is the time that the city and applicant would work through any road improvements. While some roads are being built by Polygon, we need to confirm that the roads are correctly based on Shelter's traffic analysis. Also, there are roads that Polygon isn't building/analyzing, such as Discovery, and an area of roadway easement that would be relinquished back to a retail block. This isn't just a risk to Shelter. By pursuing SDPs before we have resolved roads, we may be wasting staff's review time on SDPs whose partial shapes may be altered by the plat.
Thank you. Did you provide a response in writing back to Ms. Sloman to this January 10th email?
I don't recall.
Okay. And I'm paraphrasing and doing the best I can to quote the specific statement that you made, but I believe it was something along the lines of a complete permit application determination is a ministerial decision based on a checklist. Do you recall your testimony to that effect generally?
I think I just said it, yeah.
Okay, yeah, okay. Doing my best to write that down. To your understanding and knowledge, Mr. Mullaney, does the 1996 Issaquah Highlands Development Agreement contain an applicable checklist for this purpose in regards to determining the completeness for an ASDP or STP application?
I'm not sure whether it does or not. I'm not aware. I'm trying to think. It has Appendix L in it, but I don't recall if that had specific checklist items in it or not.
In your reference then to a ministerial decision based on a checklist, what checklist would you be referring to?
Well, my understanding of vesting law is that the local jurisdiction has the ability to determine the criteria for a complete application so long as it doesn't put a bunch of preconditional hoops on an applicant that would otherwise delay the vesting. And so and I know that the Issaquah Code has provisions in it that say that that have the requirements for a complete application.
But do you know, or do you have a position on which document would apply, whether it was the code or the development agreement in providing that checklist, quote unquote?
I'm not, as I said, I'm not sure if there's one in the development agreement or if the default was to rely on the code. The shelters consultants, the people who put the application packets together, were the ones who addressed that. So I didn't have direct knowledge of which form was being used.
And who at Shelter would have done that, would have put that together?
I'm not exactly sure. I imagine it would have been part of their development team working with their outside consultants, but I don't know myself who that person would have been.
Thank you. No further questions.
You need this back?
I have just one or two questions, clarifying questions. Patrick, you were asked about any other instances where, and I'm going to paraphrase, but Mr. Lowe had asked you about instances where you'd been disappointed in the behavior that the city was engaging in with respect to Shelter versus other applicants. And you had named off Sarah Hoey and then also John Haas. Were there others in the Issaquah Highlands that, in your opinion, were being treated differently than Shelter?
Polygon is another example.
You were also asked about the November 21st email exchange and Director Niven's acknowledgement of yes, that Shelter's pre-applications were vested. Was there any question in your mind when you received that email that Director Niven intended for Shelter's applications to be vested?
No, that's, I mean, his answer is one word, and it's hard to couch an unequivocal yes as anything other than you're vested, particularly given the specific question that Ms. Heim had asked, are we vested?
Thank you. No further questions.
Okay. So I think you have additional witnesses.
We do. We're going to call Ms. Heim next, and I'm happy to begin, or we've only been going for about half an hour, so keep it going.
Yes,
Happy to.
ma'am.
This one?
Yeah, it just picks it up. There you go.
Yeah.
Ms. Heim, I think you'll need to turn that microphone on.
This one's on, I think. Yeah?
Couldn't see a light. Do we need to make sure she's under oath?
Yes, I can verify. Ms. Heim, you've joined us before for your testimony. Are you still under oath testifying today?
I am.
Thank you. So I'd actually like to start, since it's fresh in our minds, with the exhibit that the city just introduced, C66. There's a bullet point, 1, 2, 3 bullet points down there, where Ms. Sloman writes, I've communicated in the pre-app meeting separately with Eric and Tia the problem described above. Tia had indicated that there wasn't an expectation of reviewing the SDPs until the plat was complete. However, that was not what was written in the SDP resubmittal. If that had been there, I would have been more comfortable with the SDPs. Is that an accurate statement in your recollection?
We did have a conversation about the order in which permits would be reviewed, and that's accurate in that it states that we didn't expect the SDPs to be reviewed before the plat. However, what it leaves out is that we did expect the plat to be reviewed, and that didn't happen. And so that was what was causing this whole issue that Ms. Sloman was raising about the plat, the preliminary plat having not been approved yet.
So let's talk a little bit about the plat. Do you recall the testimony from Jean Lynn and Director Niven about the statement that shelter included on the plat?
Yes.
And if you could turn to Exhibit S50E in your exhibit binder. So can you describe what's at S50E for us?
This appears to be our preliminary plat submittal.
And there's some teeny tiny little language there that Director Niven talked about, as well as did Ms. Lynn in their testimony. Do you know who drafted the language that they were referring to?
Yes, so I think you're referring to number 7 under the notes, and I drafted that language.
Did you base it on anything when you were drafting that language?
I did. That language comes directly from the letter that Mr. Niven wrote on March 27th, 2017 regarding vesting and how building permits, site work permits, and SDPs vest through plats.
And I think, but just to confirm, could you turn to S13 in that same binder, please?
Yes.
Is that the letter that you were referring to?
Yes, it is.
And so what language were you looking at that you were mirroring in the plat application?
So in part in the, I guess it's the second paragraph, the second sentence reads, "The final plat and building permits will be processed based on the vested 2 zoning and development standards under the Issaquah Highlands Development Agreement, irrespective of whether the development agreement terminates, so long as the final plat is submitted within 5 years of the preliminary plat approval."
So did you take that language and essentially rework it on the plat application?
Correct. That language and I think some other language and concepts that are in this letter.
In your work in the development field, how many plat applications do you think you've seen?
Hundreds.
Is it unusual for there to be general notes on a plat that address the regulations that apply to them?
No, I mean, the general notes section of a plat address different things depending on the jurisdiction and the regulations and the preparer and the situation. I mean, that's the place where you put specific things. So it's not uncommon at all for there to be something specific about how applications implementing a plat would be reviewed or considered.
If you could turn next now to Exhibit C49, please.
Okay.
And what's the document at C49?
This is an email to me from former Mayor Fred Butler.
I think we'll move past this one for the moment because we've got the wrong exhibit number here. So we'll come back to this one in just a second. Did you hear Ms. Sloman testifying about the distinction between short plats and preliminary plats?
I did.
Why did Shelter prepare a preliminary plat application?
We prepared a preliminary plat application at the direction of the city. I think both Mr. Mulaney and myself have already testified on this, that we had initially come in with the idea that we would do a binding site plan or a binding site plan and a plat. And at our collaborative meeting with the city instructed us to do just the plat application and specifically went into detail about how the process would work as far as the sequence of permits and how that kept how vesting worked and carried through from plat to SDP to building permit.
When you submitted or when you were first discussing the plat application even prior to submittal, what did the city tell you about the complexity of your plat?
Oh, they always maintained that it was a very simple plat. There really was not much to it. There was utilities are already there into the site, so you're not dealing with any complexities in that regard. The right-of-ways are largely already constructed, with the exception of two small segments of road that will need to be built out with our plat, federal and a section of 8th.
Do you recall whether the city told you anything about how many rounds of review the city expected to have on your plat application?
They initially told us that they didn't expect to have any round of comments, that they thought that they would come back directly with conditions and that we would review conditions and then move forward through the approval process. And I think we saw that that was referenced in Ms. Lynn's notes that are already in the record.
You mentioned that, in your opinion, this is a fairly simple plat. It's an infill piece. The right-of-ways are mostly constructed. How does that compare to Polygon's plat that we've been talking quite a bit about in this hearing?
So with respect to the Polygon single-family north plat, I would say that plat is quite a bit more complex and controversial. It involved closing down an existing street and turning it into, I think, what they're calling a linear park. So that in itself added a level of complexity and controversy that definitely wasn't present with our plat.
Did you hear Director Niven testify about the alleged complexities of the SDP application submitted by Shelter?
Yes.
Did you hear any explanation of why they were complex?
No, I thought he struggled to try to articulate something, and I never heard a reason given. I thought it was a particularly odd statement for him to be making, given that they really, one, haven't identified anything particularly complex, except for the fact that they were trying to change the regulations that applied to the SDPs midway through the process. Beyond that, I haven't heard anything articulated as a basis for why they were complex. Plus, it based on the staff reports, it looks, and the testimony that we've heard, it looks like very little to no review has actually been done on our SDP applications.
So all of the insufficiency letters that we've been talking about and that are in the record now, is that considered permit review or is that application review? What was the city doing at that point?
Well, they were writing the letter as if it were a completeness review, which would have been the appropriate review to be doing at that point in time. However, the issues that they were raising included many that really are project-level reviews.
And in your experience, what's the difference between, and I'm just talking generally, between a completeness review versus a project-level review?
So a completeness review checks for all of the required parts and pieces of an application so that you make sure that you have all of the parts that the city needs to at least commence their review of the permit.
And how does that compare to project-level review?
Well, the project level review is when they're actually analyzing all of the parts that are there. So an example of this would be the issue that Ms. Sloman raised about an easement that she said was going through a building. To me, that is a very obvious project level review, whereas the completeness review would say, does the plat or site plan show the easements? Is the title report included? Are the copies of the exceptions to the title report available or included? And it wouldn't get into how a particular easement may or may not impact a potential development.
And so from what you were saying, in terms of the order of operations of those two things, which comes first and which comes second?
Completeness review comes first. Once the application is deemed complete, then they start the project level review.
Does the December 2017 plat submittal that we've heard about, does it reference the SDPs?
It does. It shows the SDP footprints, and when we submitted that supplement, we did it in two ways. We went into mybuildingpermit.com, which is the preferred submission method for the city, and we uploaded it into our file there. We also wanted to make sure that our project reviewer knew that we had submitted some additional materials, so we emailed Jean Lynn, who was our planner, and explained that we had uploaded the materials. We also attached them to that email and explained what they were doing, in that they were showing the SDP footprints so that they could see how the SDPs and the plat were consistent.
Did you hear Ms. Sloman's testimony suggesting that Shelter should have told her when the supplemental materials were submitted in December of 2017?
I did, and I thought that was strange because she wasn't our reviewer, and we did go beyond what would have been required and notify our planner directly. Ms. Sloman is Ms. Lynn's boss, so if they don't communicate with each other, that seems like an internal city issue and not something that we would have needed to correct for.
Is there anything that you're aware of that prohibits an applicant in Issaquah from providing supplementary materials to the city?
No, there's nothing in code that I'm aware of, and in fact, I think it would be a highly unusual case where an application that goes through review doesn't submit some sort of additional materials at some point. That's the normal course of reviewing and revising and eventually getting approval of an application.
Did you hear Ms. Sloman's testimony about the timing and comments on Shelter's plat application?
Yes.
In your view, was her testimony accurate?
No, I was pretty shocked the first time I heard her review to the plat as being out for corrections since March of 2018. That's absolutely not an accurate way to describe the state of the plat application.
We've walked through the plat application in your direct testimony, and so we don't need to go in excruciating detail into every step along the way. But can you describe for us at a high level, what the sequencing was of the plat beginning back in January of 2017?
Sure. So in January of 2017, we had a meeting with Keith in which we told him that we were thinking of coming in with a binding site plan for our property. And at that meeting, he told us that the first step would be the collaborative meeting. So we scheduled the collaborative meeting. At that meeting, as you've heard lots of testimony on, was where he encouraged us not to do a binding site plan, but just to do a plat, and described how vesting would work for the plat and the plat and the site development permits and the building permits. Then, as soon as that meeting was done, we started, so at that meeting, they explained to us, Keith and Lucy explained to us, that the process in Issaquah was the collaborative meeting, then the pre-app, and then after pre-app, you could make your final submittal, or your full submittal, rather. So as soon as the collaborative meeting was done, we started asking for a pre-app, and our consultant that was running point on that was not getting a response from the city. After multiple attempts, he finally got a response that was, well, you can't schedule your pre-app until you make your preliminary land use application submittal package. Once you submit that, then you can schedule the pre-app that would be out 4 to 6 weeks. So we immediately started working on all of the elements that were required for that package, and as I testified before, that's a pretty extensive package. We submitted that. Then we scheduled our pre-app. Going from memory, I want to say it was late May by the time we got a pre-app meeting. And then pre-app notes came out in June, and we made our full plat submittal on August 1st. Immediately after that, again, our consultant that was running point was asking Ms. Lynn for a completeness determination. We were aware that the development agreement required that the city deem it complete after 10 days if they hadn't asked for anything else, and they hadn't, so what we were trying to get was a letter confirming that. It wasn't until October that Ms. Lynn finally issued that completeness determination on the plat. It was backdated to August 11th, which is when it would have automatically been deemed complete. In that interim period between August 11th and October, we had asked multiple occasions. She had promised it soon, or on several occasions. Then we started submitting site development permit applications, and were getting kicked out for being incomplete because the plat hadn't been processed, and they were articulating some reasons that were related to not being able to tell how the plat and the SDPs would potentially work together. So we made a supplementary submittal in December of 2017. And then we didn't hear anything from the city on the plat. In January, in response to one of our submittals of the medical office building SDP, we got a comment from the city engineering reviewer that related to transportation analysis, and that led to a meeting with Doug Schlepp from the city and our transportation consultant and myself. And at that meeting, Doug Schlepp, so the meeting came up in the context of the SDP that he was looking at for the medical office building, but in that meeting, he decided that he wanted to change the direction. Doug Schlepp wanted to change the direction that the city had given to us at our earlier meetings on our preliminary plat as to how they would analyze the traffic the transportation analysis as between the plat and the SDPs. So that led to us submitting a supplementary transportation memo on the plat, but it really wasn't coming out of a plat comment, as Ms. Sloman had indicated. It was a comment that came out of the SDPs that led to a complete change in the initial direction that they had given us. But still, we did it. We did it as quickly as we could. We submitted it in February. Still nothing on the plat until just a few days before the replacement regulations were adopted. We got notice that the city had uploaded into mybuildingpermit.com the plat with some markups on it. So me and our consultant team looked at the comments and decided that we needed some further clarifications from the city. So we requested a meeting, which I believe we had right at the end of March. During that meeting, we went through various things. We asked if the city would be providing us notes from the meeting, as would be normal in certain circumstances. The city said, no, it's your responsibility to take notes and do what you need to do after this meeting. We said, great. We left that meeting and we started working on revising our plat. Then a couple weeks later, in April, we received a follow-up email from, I believe it came from Ms. Lynn, that said it was follow-up on the meeting that we had, and it gave a new set of comments on the plat, which were inconsistent with the previous comments and the meeting that we had. So we were stuck. We couldn't do anything at that point. So we wrote an email back to the city saying, here are the problems that we're running into based on the feedback that you've given us. And we need clarification and we need answers so that we can resubmit. That letter went out in April, and we followed up multiple times over the months that followed, and we didn't get any response from the city other than promises that didn't end up being kept to give us response soon until the end of August of 2018. At that point, it still wasn't clear, and we needed more information. We responded back, I think, in October, in early October, and then again didn't receive a response until the end of December, I believe. And then we resubmitted right at the beginning of March, and then didn't hear anything, I don't think, until we got Ms. Sloman's April 4th or 5th letter, which we've heard testimony on here, and then her April 15th letter.
When Shelter goes through the process of preparing a plat resubmittal, what's the ballpark of how much that might cost you to go through that process?
Obviously, it depends on the extent of the comments, but you're talking about having a full team of consultants working on something. So I would say typically $20,000, $30,000, depending on what they're asking us to do. If you're making revisions to a plat, you've got your engineers, you've got your transportation engineers, you've got your surveyors. So it's not a small undertaking.
Is it an undertaking that you would generally undertake without clarity in terms of what you needed to do?
No, I mean, not only would it not make sense to do that, but we didn't have clarity on what regulations the city was trying to apply based on the comments that they had given us. They were not coming from the code, which was the development agreement. So we legitimately couldn't do anything until you understand where the requirements are coming from.
And what's your understanding of where the plat processing sits today?
honestly, I'm a bit confused. We are told that it's going to go to Development Commission for a hearing, or no, sorry, not a hearing, for a community conference, but that can't be scheduled until after this hearing unless we want to put this hearing on hold. But then the letter also said that they were going to continue to process other permits while this hearing was going. So honestly, I'm a bit confused as to what and when the city plans to take its next steps.
Has the city told Shelter what its plat application vests Shelter to?
No.
I'm about to need to pull up something on the screen, and we're about 4 minutes away from 7:30. Would you like to take a break so I can do that during the break and keep us moving?
Sure. Why don't we take a 10-minute break then?
Okay, thank you.
Okay, we're back on the air, and I'll call the meeting back to order.
Okay, thank you. So we put an exhibit up on the screen, S78. Tia, we heard Ms. Sloman testify about an issue regarding a public access and utilities easement on the plat. Did you hear that testimony?
I did.
Can you explain your understanding of that utility easement and public access easement?
Sure. So there are 3 possible easements that she could be referring to, and all are basically the same. One would be for the road segment that you can see going through between Block E and Block D. That's a continuation of 6th. The other would be between Block B and Block C. There's an extension there for Ellis. And then the last one is a road section, which is actually for half of a road, because half of the road is on the shelter property and half is on the Polygon property, and it runs along the backside of blocks B, C, D, and E. So it's sort of that thin strip that you can see along the backsides of those blocks. So what those easements are, they were for roads that were constructed by Polygon as parts of their application. So the city required Polygon to get easements from us because we were the property owner. And those easements provide that when the roads are complete and accepted by the city, that we would dedicate the right-of-way to the city upon certain conditions. So I think the issue that Ms. Sloman might have been referring to, and I'm guessing on this part, is that you can see on the Ellis section between blocks B and C, how it's wider at the top and it gets skinnier. Well, the easement, you can faintly see a dashed line. The easement actually went straight because at the time we dedicated the easement to them, they didn't know exactly what the road configuration would look like. So when the road gets dedicated, the dedication will actually follow what the roadway is in reality, and the rest of the easement will terminate. All of this is addressed in the easement document itself, which is why it's a very appropriate question to raise in the context of a project review. And it's also a very easy thing to answer by looking at the document or instructing the city to look at the document. To call that out as a basis for completeness or incompleteness, rather, is bizarre to me. It doesn't make any sense.
Let's turn back to an exhibit that we were going to look at earlier, but I gave you the wrong number for it. So what I meant to say was C41. And what was the document at C41?
So C41 is a November 22nd, 2017 letter to Nick Abdelnour at Polygon from Mr. Niven.
Was Shelter provided with a copy of this letter prior to this hearing?
I think we got a copy through a public records request, but I'm not entirely sure of the timing on that.
Do you recall receiving a copy of it around the time that it was actually sent to Polygon?
No. I did not get a copy at that point in time.
How does the letter describe itself in terms of its relation to the March 2017 vesting determination from Director Niven?
So in the first paragraph, there's a sentence that reads, "This letter is supplementary to the correspondence of March 27th, 2017, which provided you with an interpretation of vesting provisions related to your West Ridge projects in Issaquah Highlands."
Does it overrule the March 2017 determination?
It does not. I mean, in fact, that sentence indicates that it only supplements it. It does not replace it in any way or rescind that in any way.
Does this letter affect Polygon's single-family north plat at all?
It does not.
Let's turn now, if you could open up in that binder to Exhibit C3.
Okay.
And what's the document at C3?
So this is the email exchange between Keith Niven and myself, which started on November 21st, and the last exchange is on November 22nd, where he confirmed the vesting of our applications.
Was this email exchange memorable?
Yes, it was significant because it was where he confirmed in writing the vesting of our applications, which he had been telling us verbally that preliminary land use applications vest in the city of Issaquah because of the process that they impose requiring the preliminary land use application.
Did you have to seek clarity from Mr. Niven within that email thread?
I did. The first time I asked the question, he seemed to try to dodge a direct answer by saying, unless you have received a request from city staff for additional information, these applications are viewed as complete per the terms of the development agreement, which was only half of the question I had asked. I asked if they were complete and vested to the development standards in the development agreement. So I followed up, and he gave a very short and clear yes.
And from the short and clear yes, what was your understanding of what that yes meant?
That our applications were vested to the development standards in the development agreement, and that our applications were complete.
If you could turn to C4, the next exhibit, please. And what's at C4?
So this is a continuation of that email string, but I am not on it. This goes on to an email exchange between Keith Niven and Lucy Sloman.
If you could, I'm going to put in front of you testimony from Director Niven from the April 16th, 2019 hearing. I'm at page 51, line 3. If you could just read beginning at line 3 through 14, please, for us.
Okay. Question, was IHIFC courtesy copied or otherwise forwarded a copy of that response from you? Answer, no. Question, did you follow up with IHIFC to clarify your statement or your intent? Answer, I don't think so. Question, can you explain why you didn't follow up? Answer, well, I thought they asked a very simple question, which I provided a very simple answer. I felt like if they didn't understand my answer, they should have asked for clarification on what my intent was. Do you want me to keep going?
You can pause there.
Okay.
After you received the Director Niven's yes in his email, did you have any questions about what his intent was?
No, I don't think it can be more clear. I asked a question, he answered half of it. I asked him to confirm that his answer was with respect to my whole question, and he confirmed that it was.
Was Director Niven's response in that email consistent with what he had told you before about vesting?
Yes, I mean, the whole reason that email string started was because we had had a meeting, and he had told us yet again that preliminary land use applications vest in the city of Issaquah. And so I asked in the meeting, so does that mean that our preliminary land use applications and our plat application are vested to the development agreement? And he said yes. And I said, okay, can we get that in writing? And he said, send me an email and I will confirm. So that's what started this whole thing. It wasn't just something I decided to do on my own. It was follow up to a conversation and at his direction.
Okay, and I'm going to ask you to turn now to, in the same April 16th transcript, page 67 through 68. And starting with lines 21 and ending on line 4 on 68. Will you please read that into the record for us? And again, this is Director Niven's testimony.
Question, did the outcome of the landowner's decision not to pursue the college campus proposal in any way affect or influence your subsequent treatment of IHIFC's various project applications? Answer, no. Question, did you ever state to IHIFC that the college campus decision would impact your treatment of IHIFC's project applications? Answer, no.
Is what Director Niven testified to in that hearing true, in your opinion?
No.
Why not?
Because I attended multiple meetings with him where he referenced the fact that we didn't give them the college campus or let them do the college campus as the basis for our applications not being received favorably. You also saw that even in Miss Lynn's notes when she was brought up to speed on Issaquah Highlands and our project, in the section that references direction from Miss Sloman, she notes that we were supposed to give them a college campus and we backed out. It was clearly something that continued to be an issue for city staff.
And are Ms. Lynn's notes, are those the notes that are in the record already at S47?
Yes.
If you could turn to C44, which should be a set of meeting minutes. And can you turn to the September 21st, 2016 meeting minutes in there, please?
Okay.
You look on the third page of those notes. There's a bullet point that's about halfway down the page, a little more than halfway down the page, that starts with staff does not and will not. Will you please read that bullet point for us?
Staff does not and will not support Shelter's proposal for a mixed-use development, in part because Shelter refused the city's past overture to tie up Shelter's property for 5 years while the city attempted to market it to an institutional user. Keith mentioned that had Shelter made a different decision, the 5-year period would have almost run by now, and that staff might have looked more favorably on Shelter's proposal.
Is this one of the instances that you were referring to a moment ago, where Director Niven had referred to the past decision to not pursue an institutional user?
Yes.
Were there other instances?
Yes.
Did those also occur in meetings that you had with Director Niven?
Yes.
Let's talk a little bit about the replacement regulations. Did you hear testimony from Keith Niven and Ms. Sloman that Shelter was trying to slow down the adoption of the replacement regulations?
Yes.
Is that true?
Yes.
Why?
Because, well, for a lot of reasons, but because the replacement regulations were not well thought through. They were being pushed ahead quickly in order to terminate the development agreement. They were not being portrayed to the public accurately. So for example, the goals of the replacement regulations were always stated from before they were drafted until after they were adopted as the same, even though the content of the regulations had changed considerably. The most glaring example of that is that one of the stated goals, and there were only 3 or 4 goals stated, was that they wanted to create as few non-conforming uses as possible. Yet when it came down to it, when they decided to impose the minimum FAR, they effectively created non-conforming uses for almost every non-residential use in Issaquah Highlands. So either they should have been acknowledging that they were drastically failing at meeting their goal, or change that goal, but instead they just kept saying the same things regardless of what the replacement regulations were actually doing. So that was another one of the reasons why we asked them to slow down and consider what they were doing.
How was the community outreach for the replacement regulations? What was your perception of that?
Well, at the point in time that we were asking them to slow down, we were telling them that they owed it to the community to do more outreach and really educate people as to what they were saying was the original vision. Because we had done extensive outreach to the community and had really spent a lot of time there talking to people and understanding what people wanted in the commercial area of the Issaquah Highlands, and very few people really were wanting huge commercial buildings or very dense development. The majority of what we were hearing were people who wanted more restaurants, more retail, more entertainment, more uses that they and their families would use. But that feedback was being ignored. We were trying to explain that really this new zoning didn't allow development of additional retail like Grand Ridge Plaza, which is what's up there now. So throughout the process, we had objected, actually from the very beginning, when they first outlined what the process was going to be for adopting the replacement regulations. We had written a letter to the mayor and council saying that we did not think it was a good idea for there to be a period of months and months of time where only staff was working on the replacement regulations without any interaction with the landowners and the community. And our concern was ignored.
Did it seem like staff was trying to rush the council to a decision?
Yes. At one point, staff even sent out an email to the interested parties that said that action wouldn't be taken at a particular meeting, and I can't recall the date off the top of my head, but it would have probably been in December. So they sent out the email to the interested parties saying it's going to be on the agenda, but there won't be any action taken. And then later that week, when the staff memo came out, it recommended that council take action on that night when they had told the public that it wouldn't take action that night. Now, council did not end up taking action that night, but still staff had recommended it, which seemed disingenuous to me.
So if Shelter had vested applications or has vested applications, why did it care about the replacement regulations? Why was it so involved in that process?
Well, one, our applications don't cover every inch of our property. But two, when you own property, you do and you should care what the zoning says. It seemed pretty basic to me.
So did the adoption of the replacement regulations matter for Shelter's vested permits?
No, not at all. When you have a vested application, that is what it means, is that they are vested and are considered under the regulations in place at the time that they vest. Meaning when regulations change, your application is still considered under the old regulations. Any other definition of vesting would actually not be vesting at all.
So when the replacement regulations, the recommendation ultimately changed in early 2018, why did Shelter protest so loudly that version of the replacement regulations?
Well, I think we had been protesting that as an option as long as it had been proposed as an option. So initially there was a recommendation of vesting language which was consistent with the West Main versus Bellevue case and the process that Issaquah uses of requiring a land use permit prior to building permit. In either November or December, they started having this other option in the background that was not the recommended option, but you could do this other thing. We objected to it then, too. We said we support the recommended option in November. And by the way, you should not be considering this other option because it's illegal. And so why were we objecting so loudly when it changed in February? Because it's an illegal option that staff had put forward for council to consider.
In your mind, does the fact that the staff had informed you about this new option make it any less illegal?
No, that's a theme that we've heard in the testimony a lot. It was, didn't you know? Didn't they tell you? Just because someone tells you that they might do something illegal doesn't make it legal. It's sort of mind-boggling to me that that's being put forth as a justification for taking action that's just not authorized by law.
Did you hear the testimony from Ms. Sloman and Director Niven about the recommendation in terms of the replacement regulation language from staff?
I did.
Did the recommendation from staff for the vesting language change?
It did. So as I was just starting to describe, the recommendation that initially came out in, I think, October of 2017 was to recognize vesting occurs at complete preliminary land use application, and that SDPs and other land use permits vest. This was based on the West Main versus Bellevue case. The staff explained that, as they had many times, and it was based on the fact that they require both a preliminary land use application and a site development permit application before you can submit a building permit. That was their original recommendation. It changed it changed publicly in February of 2018. I think certain parties knew that it was changing earlier than that. We did not. I thought that the testimony that Ms. Sloman and Mr. Niven gave regarding the staff's recommendation was not accurate because they testified as if the council went on their own and didn't follow staff's recommendation, when in fact what happened was staff and the administration changed their recommendation, and council acted to adopt the staff and administration recommendation.
You mentioned that the recommendation, when the recommendation had changed, that was possibly communicated to others but not to Shelter. Who were some of the other people that it was communicated to in advance of that change?
It was communicated to John Haas in advance because they wanted him to come in and get his building permit application in so that he could be vested. It was communicated to Sarah Hoey at Issaquah Highlands Community Association. At some point, I believe in October, she told me that she had received a call from Ms. Sloman telling her that the vesting provisions in the replacement regulations were likely to change and that she should submit a short plat as soon as possible. Ms. Hoey was asking me what I knew about this because it seemed very odd to her that she would need a short plat when she had a small lot on which she was trying to build a single building. She had no need for land division. She also had concern that, it was a huge additional cost to the community association and that her consultants couldn't act fast enough to get an application in and vested as Ms. Sloman had suggested.
Outside of the conversation that you had with Ms. Hoey or conversations that you had with Mr. Haas, did the city directly tell you anything about the replacement regulation language changing?
No.
Did you hear Director Niven's testimony that Shelter never supported the originally proposed replacement regulations?
Yes.
Is that true?
No.
How did Shelter support them?
Well, I think he was referring to the vesting language within the replacement regulations, and he said that he didn't think we had ever supported it. We supported the initial recommendation, both with verbal comments at public meetings, either at Land and Shore or at council, and also in letters.
And the initial recommendation, just so that we're clear in the record, what had that provided for?
It provided for vesting of preliminary land use applications and land use applications, in
So ju-
addition to the building permit, plat, and development agreements.
So it recognized those things explicitly.
Correct.
Right, if you could turn now to Exhibit C7, please. This, the chart, let's see, on the third page of C7 was brought up a moment ago in the city's cross-examination of Mr. Mullaney. Can you describe what this chart is?
It is a chart that was included in a December 12th, 2017 memo from Mr. Niven and Ms. Sloman to the City Council, and it lists all the pending permits in Issaquah Highlands. And let's see, does it have Talus in here too, or just? I think it's just, oh, no, it's got Talus in here also.
Did you hear Ms. Sloman's testimony about this table?
Yes.
What was your reaction to this table? What do you think of it?
I think that it's missing a column because it acts as if there is no zoning or regulations in place at the time that the table was created, which would have vested a permit application. So I think there's a column missing that goes at the end that says vested per the development agreement. And I think many of the permits that are listed here would have also been checked as being vested by the development agreement. So I think it's an inaccurate depiction of the state of affairs at that time.
Did this chart evolve over time?
Yeah, I believe that at various points in time, the city staff provided it to council so that council was tracking the status of permits as they progressed as the time went on. So when you look at what the status was at the time the replacement regulations were drafted, as soon as the staff got to a point where all of the applications that were not shelters, we were let me restate that. By the time the staff had come up with a scheme to recognize vesting for all of the permits that were not shelters, at that point, the council adopted the replacement regulations, and the staff then interpreted them as removing the vested status of shelters applications.
If you could turn back to Exhibit C44, the meeting minutes again, please. When you're there, if you can go to the meeting on February 15th.
Of which year?
Of 2018.
Okay.
Give me just a second to catch up with you here. Can Can you describe, first of all, who was at this meeting?
So this was a meeting with Mayor Mary Lou Pauley and Keith Niven and Derek Strait and myself.
And why were you meeting with the mayor?
So in early February, when the announcement came out that they had changed the recommended vesting language in the replacement regulations, it indicated that because it was a decision made by the administration, that the mayor had offered to discuss with anybody who had concerns. So immediately upon receiving that email, we started asking for a meeting with the mayor, as did a few other parties.
Did the mayor indicate whose decision it was to change the vesting language that was being proposed in the replacement regulations?
She did. She explained at that meeting that she had asked Mr. Niven to lay out all of the options for vesting for her to choose the one that she wanted, and so that she had made that choice.
Did she have anything to say about the West Main problem?
I asked her that specifically. I asked, you had a West Main problem before, which was why the vesting language was initially drafted the way it was. What legal analysis has been done to support your new recommendation? And she said that she was not aware of any legal analysis having been done. And then I believe that Mr. Niven indicated that they had now sent it to Mr. Haney to work on that answer after the fact, because Land and Shore had asked the same or similar question. So I thought it remarkable that they would change a recommendation that was clearly based on case law without having done a legal analysis to make sure that the new recommendation was in fact legal.
Based on your conversations with the mayor in this meeting, what was your understanding of what the mayor thought should happen on Shelter's property?
Well, she was clear that she wanted to give the citizens what they had expected, and that her understanding was that because Microsoft had owned the property at one point, that people expected a Microsoft campus, and that that was what they should get.
In your experience developing various projects, is that consistent with how development regulations work?
No. I mean, development regulations set the framework within which development occurs. It doesn't, public opinion can't retroactively change regulations that apply.
Did you inform her that there was no minimum or no required, in terms of a Microsoft-type campus, required campus or density that had to be built on Shelter's property?
Yes, so this was something that often would come up in conversation with various city staff or elected officials to some degree, that, you know, that there was some amount of commercial that we were supposed to build. There's no requirement in the development agreement that any amount of commercial gets built. So I explained that to Mayor Pauley, and I think her response was that people would be shocked to hear that. And then at some point in that meeting, also, Mr. Niven told me that we at Shelter had made our problem worse by buying additional development rights from Port Blakely, because in his way of thinking, because we had purchased more development rights, we were going to be required to build more development.
Is it true that just because a property owner owns the right to develop a certain amount, that the property owner is forced to actually develop that entire amount?
Absolutely not.
And your recollection of this meeting and the conversations that you had with the mayor, Mayor Polly, and Director Niven, are those based on your own independent recollection of the meeting?
Yes,
Are they also based on your notes of the meeting?
yes. It was definitely a memorable meeting. You know, we didn't have many meetings with the mayor, and this one was particularly hard to forget, given the positions that they were articulating to us at that meeting.
We've talked about your notes of various meetings at great length in this hearing. And I think you've touched on this before, but are the notes that you take, are they necessarily exhaustive of every single thing that's said in a meeting?
No. There's no way I can capture everything that's said. I take notes by hand typically, and then after the meeting, go back and type them up. But they're by no means a transcript of what happened, but they are accurate.
But as you testify and you're testifying to events that happen in these meetings, are your recollections based in part on the notes? Or independent recollections of those meetings?
I think I've used the notes as a way to jog my memory, but I also have independent recollection of these meetings.
Let's talk about building permit applications in the city of Issaquah. Did you hear Director Niven testify that he's now decided that the November 2017 memo where he and the city attorney said that the city has a West Main problem is inaccurate?
Yes, I heard that.
Did he tell you that before this hearing?
Nope, in the hearing was the first time that I had heard him say anything about about that memo being inaccurate.
Were there opportunities where he could have corrected himself?
Absolutely. Pretty much every public meeting after that issue was raised. Most letters that we submitted also raised that, or in many cases cited to his memo. Yeah, I mean, it would be shocking if he actually believed that was false and never took the opportunity to correct it in the many months since that was issued.
Did you hear Director Niven testify now that the city doesn't require an approved land use permit prior to a building permit?
Yes.
In your experience, is that true?
No.
Does the city require a land use permit prior to deeming a building permit application complete?
I don't know what they're doing today. I know that up until this hearing started, that they absolutely were requiring land use permit before building permit.
Is that something that arises out of the code or guidance or both? What's your understanding of what the city's been relying on to enforce that requirement?
Sorry, to enforce the requirement that a land use permit comes before?
Land use permit before a building permit.
Well, I think that the submittal checklist is the most clear indication that that's what they've been doing. But they also would say, I mean, they told people that all the time. We've already heard in this hearing, we watched a video of Ms. Sloman explaining that at a public meeting, that the city requires a land use permit before a building permit. They called them linked permits, and they explained that linked permits are what caused the issue under the West Main versus Bellevue case.
So Ms. Sloman explained that publicly in a meeting. Were you present at that meeting?
I was.
And Director Niven said it again in his November 2017 memo?
Yes, I'm not entirely sure the date of the meeting where Ms. Sloman stated it. It might have been the meeting that followed that memo. The memo may have come first, but they've said it many times.
I'd like to look now at a part of the code. It's 1801050, and I have a copy of it for you just for your convenience. Zach, do you need a copy as well?
No, thank you.
Okay. So if you could look at 1801050, and I'm looking at subpart C1A. And I'll read it to keep things moving along. It says, what constitutes a fully complete permit application? And it says, a building permit, short plat, and/or a preliminary final plat application is defined as fully complete only when all of the following conditions are met, and then it goes through a variety of conditions. If you could look down at subsection 2C, it says the application includes the following items, and then C. What does section C say?
Supporting documents as required by submittal requirements published by the permit center. And
In your experience, working through the code, does that include things like a building permit checklist?
it does. I mean, that's why the city posts them on their website under the submittal packet requirements.
Did you hear Director Nivens and Ms. Sloman's testimony about that checklist?
I did.
What was your reaction to their testimony?
Surprise. It seemed, again, highly unusual for the Director of Development Services to act as if he had never seen the building permit submittal checklist until this hearing. I believe that's what he testified to. It's a normal part of the development process, and it's something that is posted on the city's website for applicants to use. It's something that is used when you submit an application. So for either of them to act as if they were not familiar with that document or had never seen it, it just made no sense.
Did Director Niven go on to testify about how that document's applied?
Sorry, can you say that again?
So you just explained how Director Niven had testified that he wasn't aware of the building permit checklist prior to this hearing. Did he go on to explain how the city has applied it?
He did. Then he later testified about the intent of the checklist. So again, seemed strange that something that you've never seen and are not familiar with, that then moments later you know the intent of that same document.
In your experience, is the building permit checklist just a practical consideration, as Director Niven stated?
I guess I don't really know what he meant by practical consideration, but it is probably the document that most intently guides the submittal of any application. That's the list. I mean, that's the thing that you're going through, making sure that you have every single thing on there covered in order to get to complete application. Because again, you're always, in the development business, you're always trying to move your applications forward as quickly and smoothly as possible. So you want to put together the best application you can with all the pieces that are necessary so that the jurisdiction can review and approve it quickly. And the checklists are the guide that we all use to do that.
Does simply submitting materials to the city for a building permit gain you a vested status, or does there have to be something more?
Your application has to be deemed complete in order to vest. So complete application is always the thing that, for purposes of vesting and for purposes of just getting your application processed, complete application is always the thing that you're seeking. Submitting an application without being able to get to completeness has no value to any developer or landowner.
Why didn't Shelter submit for a building permit?
For a variety of reasons, but one was because the city required a land use permit prior to building permit, so we were trying to do those so that we could then submit the building permits once we had the land use permits. The other reason is, you have to remember that we were working under the development agreement, development standards. That was the only set of regulations that we had available to us to use. The development agreement does not distinguish between a land use permit and a building permit for purposes of vesting. Both are defined as implementing approvals. And so for us to decide to seek one over the other would make no sense. We would have had to assume that the city was going to disregard everything in the development agreement, which was the only code that we had to work with, but then still recognize something under some other law. So we didn't seek a building permit because we were seeking the vesting permit according to the regulations that applied, and because that was the permit sequence that the city required.
So earlier in your testimony, you had said that in January of 2017, when you met, that Director Niven had laid out a vesting strategy. I'll summarize that for you. Can you describe that vesting strategy or sequence for us?
Yes, and I think it was actually in the March collaboration meeting in March of 2017. But the vesting strategy that he laid out was that we should apply for our preliminary plat, and that would vest for a 5-year period in which we would need to submit the final plat. The final plat would then keep us vested for an additional 5 years, within which we would need to submit site development permits to implement the plat, and that each of those site development permits would be valid for 3 years and would keep that vesting alive for any building permits that were submitted within that 3-year. So he explained the sequence of permits and how the vesting carried through from one to the next.
So a minute ago, we were talking about a meeting that you were present at in which Ms. Sloman had testified about the city's, or had told the public at least, about the city's requirement that an applicant have a land use permit prior to a building permit.
Yes.
So that was the November 21st, 2017 meeting. We've heard of that before. If you could please turn to the December 5th hearing transcript. And I'm looking at, if you could turn to page 54 of that transcript, please. And start reading, just read to us lines 17 through 25, please. And this is Ms. Sloman's testimony.
So line 17 says, video is played. Ms. Sloman, we are specific that we only are vesting the ones that are vested by state law. Now, there was some concern or discussion around West Main versus Bellevue, which is a land use law case that if you have linked permits, that those permits become vested. So in our case, to submit for a building permit, you have to have an approved land use permit.
So in that, what you just read was a recording of that, of what Ms. Sloman had said at the November 21st, 2017 meeting that we played into the record on December 5th. Is her statements as they're in the record, are those consistent with your recollection of what Ms. Sloman said at that meeting?
Yes.
Is that statement from Ms. Sloman consistent with her testimony and Director Niven's testimony at this hearing?
No.
You could turn to Exhibit C65, please.
Yes.
What's the exhibit at C65?
So this is the chart that Ms. Sloman put together to demonstrate that there were some examples of when she thought a building permit and land use permit, or building permit had been submitted prior to land use permit approval.
What was your reaction to this chart when you heard Ms. Sloman testify about it?
Well, I thought that the chart actually demonstrates that they do not usually allow a building permit to be submitted prior to land use approval. So if you look at the first, let's see, 1, 2, 3, 4, 5, 6, the first 6 on this list are quite old. They range between 1998 and 2006. We don't know what the city was actually doing or telling applicants or what the permit checklist said at the time of those applications. So to me, those are not really relevant to whether they routinely require the land use permit approval prior to building permit. So then if you take a closer look at the 3 that are left, you have one for the Issaquah Middle School. That one, if you dig into it a little bit, there is more explanation there that might explain the timing of when the building permit was allowed to be submitted. So there are a couple things to note. One is that when the school district processes applications in the city of Issaquah, they routinely get modifications to the applicable code standards, and that's been discussed in open meetings on other topics. So there's that consideration, the fact that it is the school district. But if you look at just the types of approvals, there was actually both a site development permit and a master site plan that the school district was seeking. And so when you have those 2 applications, you have, I'm blanking on the term, but consolidated permit review. So you have a master site plan that is a council decision, and you have an SDP that is a commission decision. And when you do consolidated permit review, so that you can combine and have one hearing, you just take both permits to the higher decision maker. So instead, they went to a commission for recommendation and then the council for a decision. So if you look at the way the dates line up, when they let the building permit come in was after it might have even been this commission, recommended approval of the permit. So that's the point at which normally the SDP would have been decided. So when you put that in the context of the testimony that Ms. Sloman offered earlier in this hearing about, feeling certainty of decisions and things, that explains the timing, and they're actually just a few days apart, I think. So to me, that's an anomaly. That's not an example of how the city does business. The next one is a duplex. That's a really small application. I don't know that demonstrates, again, the way the city does business. And then the last one, the Sunset Way duplex, that's something that is in process during this hearing when there has been a large amount of conversation and testimony on what the city should be doing with respect to their normal operating procedure of requiring a land use permit prior to building permit. So to me, this actually is a pretty depleted list that doesn't really prove what I think Ms. Sloman intended it to demonstrate. And it actually shows that they don't allow building permits. If you go all the way back to 1998 and this is all you can come up with, I don't think it demonstrates that that's the way they do business.
It's 8:30. I can keep going, but we're an hour past our last breaking time. Happy to break or happy to continue, either one.
Can you give me a sense of how much additional time you would like? Multiple pages?
There's multiple pages. It's going to be, I'd say, another hour or so.
Let's take a 10-minute break.
Okay.
Thank you. Okay, we're back on the air, and I'd reopen the meeting. Ms. Carey, you're on.
Thank you. Tia, did you hear Director Niven's testimony regarding the minimum 1.0 FAR that's imposed under the replacement regulations?
Yes.
What was your reaction to his testimony on that issue?
Can you be a little more specific with the question?
Sure. Did you think that his testimony was accurate in terms of the way that he was characterizing how that FAR was developed?
No, because he didn't explain what had been explained to us, which was that the minimum FAR of 1 was conceived by taking the full allowable development that we had and applying it to our property and then dividing it in half. So he thought, well, the way he described it to us was you have 1.8 million square feet of allowable development that you are, in his terms, supposed to build on your property. And you have 900 and some thousand square feet of property. So if we were to require you to build half of your allowable development, that would equal an FAR of 1, because FAR, again, it reflects the ratio between the area of the building and the area of the lot.
Did people express concern about the 1.0 FAR when staff proposed it?
Yes, in addition to us, others also expressed concern.
And you just testified a moment ago that staff had developed the minimum FAR based on Shelter's property. Is that consistent with what Director Niven testified to?
No, I don't think so. I don't think he ever explained that it was directly related to our property. So although it applies to other properties, it was developed based on particulars with respect to our property.
In your experience, is a minimum FAR a tool that is commonly used by jurisdictions?
No, I wouldn't say that it's common. I think FAR is a common tool that's used, but more often it is a maximum FAR, which is actually what the Highlands had in the development agreement, was a maximum FAR.
Did you attend the September 28th, 2017 PPC meeting?
I did. That was the first hearing on the replacement regulations.
And for the record, what's the PPC?
Planning Policy Commission, I believe.
Do you recall Director Niven talking about the minimum FAR at that meeting?
I do.
And do you recall Fred Nystrom testifying at that meeting that the minimum FAR affects Shelter differently than anyone else in the Highlands?
Yes, Fred testified, we thought accurately, on how it impacted Shelter more significantly because we were the major undeveloped property in the Highlands.
Have you seen the video of that September 28th, 2017 PPC meeting?
I have.
Where is that available?
It's on the city's YouTube channel.
So I put a video that's paused at a segment up on the screen. And the title down below the video, it's on the YouTube channel. It says Issaquah Planning Policy Commission, September 28th, 2017. Tia, is this the meeting that you referred to that you attended and you've reviewed the video for?
Yes.
So I'm going to play just a short clip of this into the record, and I'll represent for the record, since this is up on the screen, that the person on the video talking is Director Niven. It shows him here.
parking. As much as y'all love Grand Ridge Plaza, we were actually kind of disappointed in Grand Ridge Plaza, and Connie's nodding her head, and Nina's nodding her head, because it was less dense than what we wanted. But we pushed that developer to give us at least one parking structure, and that's east of the cinema, and it's because, you know, we didn't have the tools to make them do anything more than that. And so I guess, you know, as we're sitting here defending putting a new tool in place, I think it's because it occurred to us that without that, they could build single-story retail with surface parking, single-story commercial with surface parking, and there's nothing to stop that, you know, except for the requirement for structured parking and putting some sort of minimum FAR on the project. So our
Tia, do you recall Keith Niven making these comments in that meeting?
I do, because we had just come in to speak with him in early September, I believe it was on the 7th, to tell him that we were coming in with site development permits for 2 of our applications. And the 2 that we had informed him about were the retail, which we had described as similar to Grand Ridge Plaza and complementary of Grand Ridge Plaza, and then also our medical office building. So at the time that this FAR was introduced, they were completely aware that we were pursuing single-story retail, which is exactly what he calls out in that clip as the thing that he wants to stop.
At the end of his statement that we just played, he said putting some kind of minimum FAR on the project. Did you understand that to refer to Shelters project or some other project?
Yeah, his reference, I think that's a good thing to point out, it was to project. It wasn't to all of the Highlands. It wasn't to all of the Highlands and Talus, which is what the regulations were to govern. So it was telling that he referred to project when he described the minimum FAR and why he needed it.
So I'm going to play another clip. Again, this is, I'm putting up on the screen, again, a video clip from the Issaquah Planning Policy Commission, September 28th, 2017 is the title of this YouTube video. And we're playing a clip of that beginning at the 1 hour 24:55 mark. And just, Tia, again, for the record, is the video that's up on the screen, do you recognize this as the video recording of that meeting that you reviewed?
Yes, it looks like it is.
5 blocks, so I don't know. They may have phasing ideas. I'm not sure it worked with the scheme that we had seen. So I'm not quite sure how what they're proposing now could then be phased in to meet a higher use of their zoning cap.
Do we have any other areas where with a retail zoning, we have an FAR minimum requirement one? The approach I'm taking, as much as I am not in favor of multi-use residential on that property to add more residential to the Highlands, I think it may become difficult to have that kind of an FAR in the current economic situation without including residential in that. So I'm trying to think if there are other situations where retail has required that.
So I can't imagine if you're not building 2-story retail.
When Ms. Sloman was speaking at that meeting, did she acknowledge that she had seen Shelter's proposals?
She did. The very beginning of that clip, she referenced the proposals that she had seen to date. So at that point, she had seen a site plan for our medical office proposal, SDP's proposal. And I don't believe she had seen the retail proposal, but the fact that we had described it in the way that we did to Ms. Sloman and Mr. Niven as being comparable to Grand Ridge Plaza was indicative that it would not meet an FAR of 1. In fact, most retail developments, unless it was a mall, an indoor shopping mall, aren't going to meet an FAR of 1 under Issaquah's code. So when I heard Ms. Sloman testify in this hearing that she did not know what our proposals were at the time that they introduced the FAR, I found that to be inaccurate, and I think that this clip demonstrates that she had seen a proposal at that time.
And just for the record, because I think I omitted this in introducing the clip played of Director Niven speaking, I believe that began at the 1 hour, 22 minutes, and roughly 50-second mark. Tia, will you please turn to Exhibit C61?
Yes.
What is the document at C61?
This is an email exchange between Director Niven and myself primarily. Gary Young and Lucy Sloman are copied on it. And it came out of an October 24th, 2017 meeting that we had with Mr. Niven, where he asked us to come up with an FAR on a block-by-block basis that would average to an FAR of 1, because he wanted to make sure that they got the development that he felt that they were entitled to under the development agreement, or at least half of that. So he had asked us to come up with a proposal on a block-by-block basis that could average to 1. He felt like this would potentially allow us to still do some of the residential, or not residential, it would allow us to do some of the retail and just develop the other parcels more densely. But the driving factor for him was that we had to average 1 over all the blocks so that that total amount of minimum development was meeting his requirement.
Did you hear Ms. Sloman's testimony about this back and forth regarding the FARs being cooperative?
I did, and I think initially it was sort of cooperative, that Keith had asked us to do it, and we were always looking for ways to get things resolved. We were not wanting to end up in this situation at all. So when he asked us to look at that scenario, we did that, and we developed something that we thought we could live with, and we sent it to him. Of course, we also, as part of this, asked him to continue to acknowledge what he had already been acknowledging, which was that preliminary land use applications would vest. So our applications that we had already submitted or were in process of submitting would be vested under the development agreement, and this FAR would apply to future development or additional development or development on blocks that weren't covered by our SDPs that were vested. So it started off collaborative and cooperative, and then we went back and forth a couple of times, and then whenever the next Land and Shore meeting was, Mr. Niven called me at, I think, 4 something the day of that meeting and said, we want to present your proposal to Land and Shore tonight. And I was caught off guard by that, because we hadn't really gotten to the point where he had indicated for certain that he would support it. So I asked him, are you supporting it? And he said yes, that he would support it. And I explained that I wasn't comfortable with it just being presented as my proposal, that I felt that he and I needed to present it together as something that we had been working on and wanted to update Land and Shore on and get their input. He agreed to that, and I came to the meeting that evening, and instead of being allowed to present it with Mr. Niven, he had Ms. Sloman present it as part of her presentation, didn't allow me to have the opportunity to answer questions or participate in that presentation at all. And I was totally taken aback by that. And when it came to public comment, I called that out, that I wanted to clarify that that was not something that we had proposed on our own. As soon as there was any pushback or questioning of it by Land and Shore Committee, it became, Mr. Niven took the position that it was my proposal and that I had come up with it.
Did you hear the testimony regarding the Swedish Medical Office Building, Gilman Lofts, Spring Hill Marriott, in terms of how they have dealt with FAR on those projects?
Yeah, I think Mr. Niven offered those as examples of developments which had a similar FAR to minimum FAR of 1 imposed on them, which I don't think is accurate. And I think it was an issue that came up in the context of the replacement regulations and educating the council and commission and committees on what an FAR was. Staff often just said, well, look at that building. It has an FAR of 2. Look at the Costco building. It has an FAR of 9. And they would throw out these numbers and these buildings without offering the 2 pieces of information that you need to understand what an FAR does, which are lot size and building size. It's all that does is compare the 2. That's what an FAR does. But they were just giving random examples like, do you like that building? Because that has an FAR of whatever it was. So I think he did a similar thing when he offered those. Those buildings may have the FARs that he indicated, but that does not mean that those FARs were mandated as minimums. I can't tell from what he offered whether they did or did not. The Swedish Medical Office Building, if he's talking about the one in the Issaquah Highlands, it did not have a minimum FAR mandated on it. It also is significant that with the Swedish building up in Issaquah Highlands, the parking is on separate lots, or at least largely on separate lots, which would impact your FAR calculation because, again, under Issaquah code, which is somewhat unusual in this respect, the parking, even if it's structured, isn't included in your FAR calculation.
Does the use matter when we're talking about FARs?
Absolutely. A minimum FAR is very easy to meet for a mixed-use residential building, and that's where you often see FARs used.
Can Shelter meet the FAR for its retail and medical office building applications?
No, it does not meet the minimum FAR for the retail or for the medical office.
Can the storage application meet the minimum FAR?
Yes, the storage application, you've got about 105,000 square feet of building on I think it's like 35,000 square foot lot. So it clearly exceeds the minimum FAR. However, in the staff reports that the staff provided to you for this hearing, the city incorrectly calls out the storage application as not meeting the minimum FAR. So I'm not quite sure what analysis they did to come to that conclusion.
Is it feasible for Shelter to build 23 acres of storage units?
No, it's not economically feasible, nor is it desired by the community.
Are there other elements of the replacement regulations that the storage application might not comply with?
Yes.
Let's talk about the parking standards under the replacement regulations. Why is the parking standard problematic?
The parking standard is problematic because it dictates that structured parking is required in certain circumstances for certain types of uses.
And so what happened with the adoption of the SIDS and how that relates to the replacement regulations and the changes over time? And first, can you explain for us what the SIDS are?
So the SIDS are the regulations that govern the central Issaquah area. And the replacement regulations basically say if something is not addressed in the replacement regulations, then you default to SIDS. And if it's not addressed there, then you default to Issaquah Municipal Code. So when this whole process of drafting the replacement regulations started, SIDS parking regulations were fine. They did not dictate a requirement for structured parking. At some point in the summer of 2017, the city took action to amend the SIDS. And I don't know the exact timing off the top of my head, but I believe it was right around the time the first draft of the replacement regulations came out. It may have been a little bit after that the SIDS got amended to impose that structured parking requirement. And when that happened, the discussion at the council or commission levels, it had started off as a requirement for commercial uses, for I think office primarily, although I'm not entirely sure, but it didn't apply to retail. And the discussion at the commission raised the idea of retail, and then somehow when it got to the council, they decided to just incorporate retail into the structured parking requirement, despite the fact that staff was unable to find an example of any jurisdiction in the state of Washington that required structured parking for retail uses. It's just simply not feasible. It's not something that anybody requires anywhere. So that got adopted, I think, without enough attention, and then it's now applying into an area that is going to be developed for retail. So it changed midstream, I guess is the point.
Let's shift gears and talk about the Talus parcels. We heard in Mr. Niven's and Ms. Sloman's testimony about the 17B commercial property in Talus. Are you familiar with that property?
Yes, generally.
Do you know how long the developers in Talus were working to attract commercial development to that community?
I believe they marketed it as office for 20 years.
Were they successful?
No. They tried for 20 years to bring an office user to that site and could not do it.
What's become of the property now?
Well, it was rezoned with replacement regulations, and subsequently the property owner sold the property to the school district. And the school district's now applying for, I believe it's a middle school on that site.
Do you know if the school district is going to comply with the 1.0 minimum FAR?
They will not.
Why is that?
That site is approximately 9 acres, I think. There's no way that a school could meet the minimum FAR for that parcel. I've looked at the preliminary submittals that they made. Initially, they indicated that they would get to a 0.7 FAR, but that included some calculation of area or exclusion of area that was not following code. in my opinion. The next submittal that I saw that was available on the website showed that the FAR, the minimum FAR, was not applicable.
So Director Niven in his testimony, and I'll summarize, testified that no other property owners or project applicants ever contended that application of the FAR or structured parking standards would render development of their projects economically unviable. Based on your understanding of what the school district's proposing for 17B, is it economically viable for them to build to a minimum 1.0 FAR or incorporate structured parking as is required?
No, the FAR is definitely not viable for them. The structured parking might be viable for them because they're on a slope. So, I mean, there's lots of factors that go into what's viable and not. But on a sloped site, it's easier to meet a structured parking requirement. And I would point out also that another example of a property owner that described to the city why a minimum FAR was not a viable option for their site would be John Haas and the City Surf site. He explained several times at public meetings why the minimum FAR would not work on that site.
So Director Niven also testified that the city owns 2 properties in Tallis. What's your understanding of how the city came to acquire those properties?
My understanding was that they imposed a requirement to build retail on a developer, and the developer was unable to build that retail because it was not economically viable, and so the city offered to have the developer give them the property, and so that was what happened because the retail development was not economically viable.
Has the city ever indicated to you what it plans to do with those properties?
In past discussions, Mr. Niven had made comments about the city never really intending to do anything with that property because retail is not a viable use there.
Did you hear Director Niven testify that the Tallis replacement regulations were adopted before the Issaquah Highlands replacement regulations?
Yes,
Is that true?
that's not true. The Issaquah Highlands replacement regulations were adopted first, and they further delayed adoption of the Tallis regulations.
Let's turn back to Exhibit C44, please, and specifically the meeting minutes from the November 14th, 2016 meeting.
November,
14th.
okay.
And if you need just a second to flip to it myself, I'm scrolling back. Do you see the statement in your notes there with reference to Director Niven and the no gap statement that we discussed in your testimony before?
Oh, I remember that.
I believe it's the 3rd bullet point up from the bottom on the first page.
Yes.
So it reads, Keith went on to point out that with vesting available under the current DA, there is no, in quotations, gap, end of quotations, between DA and new zoning, and that the moratorium work plan indicates that the city will have lifted the moratorium before the end of the DAs. What did you understand? Well, first of all, did you hear Director Niven's testimony about this no gap reference?
Yeah, I did, and his testimony seemed to go in a different direction that didn't reflect the conversation that we had, because the conversation about there being no gap was in response to us raising the issue that because we were in a spot where now we are focusing on getting commercial users there, But everybody knows that the development agreement is going to wind down at some point in the somewhat near future, and they're going to adopt replacement regulations. We were getting a little pushback from the market saying, well, how do we know that you can do what this use is, whatever the one was that we were talking to at that point in time? And so we were communicating that to Mr. Niven, that this was a problem for us, that we felt like we were kind of caught in this gap that where there was, though we had certainty in our ability to vest under the development agreement, that users were perceiving that there wasn't a level of certainty there. And his response was to point out what we already knew, which was there's no true gap where you're not allowed to vest, because you can vest under the development agreement today, and then that development agreement stays in place all the way up until the date on which the replacement regulations go into effect. And then under the replacement regulations, there would likewise be ability to vest to those. So it didn't, all the gap discussion reflected was him specifically acknowledging the ability to vest under the development agreement.
And was that gap filling, was that intended to continue on past the adoption of the replacement regulations, the termination of the development agreement?
Well, the vesting obviously would carry on beyond the termination.
If you look at the second bullet, well, the next bullet point down, actually, and there's a sub-bullet point. It says, Keith said that the city attorney has determined that in Issaquah, the vesting date is pre-application date, in parentheses, not complete application, end of parentheses. And then mentioned that he hasn't gotten around to writing that determination down yet. Is that consistent with your recollection of what Director Niven said?
Yes, as I've testified, he's on many occasions made that statement to us.
So when, in November of 2017, in the email communications that we've talked at great length about on the 21st and 22nd, I believe, when Director Niven indicated yes, that your pre-applications were vested, was there any doubt that pre-applications vested in your mind?
No.
Did you hear testimony from Ms. Sloman and Director Niven that implied that they didn't understand vesting?
Yes.
Was that a surprise to you?
Yeah, a surprise would be an understatement. That was shocking to hear that as the excuse for why we're here today. He's the Director of Development Services, and she's the Land Development Manager, and for them to claim that they didn't understand vesting is outrageous.
Had Shelter written to them explaining what vesting is, at least from Shelter's point of view?
Many, many times. There are so many letters in the record for the replacement regulations that indicate, or that include us explaining exactly what vesting is. We also testified many times, or made public comment at public meetings many times. That's why I, on certain occasions, brought Mr. Mullaney to the city meetings to either deliver comments verbally or to write letters to explain exactly what vesting is. So to say that they could get to this point in time and then all of a sudden realize that they somehow didn't understand and it had never occurred to them to ask some element of vesting doesn't seem believable to me. They also often they often made presentations that included vesting to Land and Shore, to council, and to the general public.
Did Director Niven or Ms. Sloman make reference to the fact that they were consulting with the city attorneys throughout that time on vesting?
Yes, sometimes.
You mentioned when you were describing the sequence of the plat application, that we had talked at great length about the April 2019 letters that were received from Ms. Sloman, and that was one of the points where you kind of left off there. Did you hear Director Niven's testimony related to those letters about applying a new process to Shelter's plat application?
Yes.
Is that consistent with what he told you in the past?
No, the discussions that we had in the past, meaning before the replacement regulations were adopted, what he had told us was that if the UVDC was disbanded or went away, that the city might substitute Development Commission or a different commission for UVDC, which obviously made sense to us. If a commission doesn't exist, they can't hear our permits, and it would make sense to have another similar commission to hear them. What they are attempting to do with our permits now is something totally different, where you're changing the decision maker and the decision type. So it's not just a purely, swapping one commission for another. It's actually changing the type of the permit and the decision.
Did you hear Director Niven's testimony about how Polygon's projects weren't ever appealed?
Yes.
Does it make sense to you that those projects weren't appealed?
Yes, it makes sense. They appropriately applied the vesting to Polygon's projects. I'm not sure why anybody would appeal that.
If you could turn to Exhibit C55, please. And this is an action memo that the city introduced as an exhibit. In your understanding of the development agreement, does an action memo amend the development agreement, formally amend it?
I don't think so. I don't know that action memos are specifically referred to in the development agreement.
Does the action memo apply to permits, or does it apply to permit applications, this particular action memo?
This action memo only applies to issued permits. So basically what this action memo was saying was that since the development agreement didn't address the term of permits, you would default to the Issaquah Municipal Code, which put timeframes on permits, but that the staff was deciding that because it was in a development agreement, they were not going to apply expiration dates to those permits, but that they may at some point apply expiration dates through the termination process, through the development agreement termination process.
So we're talking about permits in this action memo. Are we talking about permit applications?
Nope, only permits, and I don't even think that they did address that through the termination process, as the action memo indicates they would.
Will you please turn to Exhibit C59? And this is a chart that Ms. Sloman had testified that she prepared for this hearing. And before we dive too far into this chart, did you hear Ms. Sloman's testimony that there were errors in Exhibit S88 that Shelter submitted?
I did.
And specifically, I'll represent that there were two. She had mentioned one with Block 4 and then one with the townhomes north. So let's start with Block 4. To help you out, there's a couple exhibits. We're going to look at S108 and 107. All right, and actually there, let's see, yep, 107 and 108.
Okay.
So looking at those, if you look back at S108 first, what's the decision date on there?
The decision date is September 7th, 2018.
And then on S107, what's the date that the application was deemed complete?
For the Block 4 affordable housing, the application was deemed complete May 16, 2018.
And so I'll represent that the chart made reference to a May 16th, 2018 date for Block 4. And so just to clarify, so there's no confusion in the record about what was being referenced in that chart, is that the date that the application was deemed complete?
May 16th, 2018 is the date the application was deemed complete.
Okay, and the decision date then was sometime later, September 7th,
Correct.
based on 108?
Yes.
Okay. And then for the Townhomes North SDP, if you could look at S110. What's the approval date in that document?
It shows an approval date of May 10th, 2018.
And I'll represent that that's the date that was in S88 on the chart. What's the date of the actual signature on that notice of decision?
The date of the signature is May 21st, 2018.
So with S88 was, in presenting that in your testimony, were you trying to be misleading at all about those dates?
Not at all. I mean, it shows an approval date of May 10th, 2018, and then the other date is the date that the chair of the UVDC signed off on the decision, which I think often happens after the meeting.
So for Block 4 and the Townhomes North SDP, both of those, where there was some question about the dates, were the dates that Ms. Sloman had suggested of September 7th for Block 4 and May 21st for the Townhomes North, were those actually later in time than the dates that were shown on S88?
Yes.
So is the city continuing to apply the development standards in the development agreement and process in the development agreement under those applications for that time?
Yes, they were.
Let's turn back now to Ms. Sloman's chart at C59. Ms. Sloman had stated, again paraphrasing in her testimony, that this was a more accurate representation to explain what's happening than essentially than what Shelter had presented in your testimony. Do you agree with that?
No, I don't. It is actually a more limited picture that narrows down what's shown in order to come to a certain conclusion that she wanted to come to.
Is the polygon short plot included on that chart?
It's not.
Were there meetings with Ms. Sloman and Director Niven that are not included on that chart?
Many.
What does this chart show about the staffing that the city had?
So this chart shows that the city was fully staffed before any of our applications came in. Well, I guess the preliminary parts of the pre-work, as Ms. Sloman called it, for our plat application occurred earlier on, but they were fully staffed by July of 2017, which was prior to submission of our full application for the plat, and prior to any submissions on the SDPs. So when we heard testimony about how being understaffed was the reason for the lack of processing of our permits, this chart proves that that is not accurate.
Do you remember hearing Ms. Sloman's testimony that there's a gap in Shelter's meetings and work between July 2014 and March 2017?
I do, and I also remember Mr. Lell making that point at the very beginning of this hearing through Mr. Niven's testimony, that they were trying to allege that we had just not done anything for years at a time. So I think Ms. Sloman was trying to make that point with this chart, and in doing so, she left off many of the meetings that we had with the city. Her explanation was that she did not characterize them as related to development of our site. I would say that every time I met with the city, it was related to development of our site. I didn't have any other purpose for meeting with the city other than to discuss development of this property, with one exception. There was one issue related to Issaquah Terrace that I met with them on, but that was a very discrete issue, and it's also not shown on this chart.
Did you hear Ms. Sloman's testimony about a theme, as she characterized it, of don't wait till the last minute?
Yes.
When was the last minute? Did the city ever tell you?
No, they never told us when the last minute started. In fact, that was a question I wanted to ask Ms. Sloman when she made that testimony. I don't know where on this chart the last minute started. No one told us when it was too late to submit. Again, we were operating under the development agreement, which were the only regulations that were available and applied to our property.
Has the city processed your applications within the timeframes provided for in the development agreement?
No, they haven't on any of our applications, which it really, everything can kind of go back to that as the cause. So we submitted that plat application in August of 2017 after doing months of pre-work that wasn't required by the development agreement, but we did it because we were trying to work with the city and just get our plat approved. The development agreement had very specific timeframes for review and approval of the preliminary plat. Had the city complied with those, or had they complied with the process, which would have made all of the pre-work optional, then we would have already had our plat approved at the time we were submitting the SDPs, which still was within the timeframe that the development agreement development standards applied. And had the city processed those timely, instead of repeatedly trying to deem them incomplete, we would have had those processed and approved prior to adoption of the replacement regulations. So all of this goes back to the city failing to follow the development agreement.
Did you hear Ms. Sloman's testimony that she worked on our applications for the SDP and ASDP applications until July or August of 2018 when Director Niven set her straight about processing?
Yes.
Is that true based on your understanding of what the city was doing with shelters applications?
No, because we got a letter so they acknowledged finally that our applications were complete in mid-March of 2018. Those were the applications that had been submitted back in December of 2017, and originally submitted even before that. And then between March, when they were deemed complete, and the end of May, when I got a letter saying, you should revise your regulation, or you should revise your applications to comply with the replacement regulations. Please let us know if you don't agree. I don't think any review was done because they were telling us to revise them to comply with a different set of regulations. We responded right away and said, no, we're not going to do that because we're vested. And then we sat and we waited for this hearing to start once we found out that that was where we were going to go, which again wasn't until August. So I didn't hear where any actual review of permits happened.
Did you hear Ms. Sloman testify that the city had retracted its preliminary application requirement and specifically with the email that's at C50 in the record.
I did hear that, and that is absolutely not true.
If you could turn to C50, please.
Yes.
So this correspondence happened on November, well, the most recent is as of November 1st. It actually starts a little bit further back. Did you meet with Director Niven after this to discuss, and did you discuss the pre-application requirement on November 6th?
Yes, we did.
If you could open up to, you can leave this open if that's helpful, but there's also your meeting minutes at C44, and there should be meeting minutes for that November 6th meeting. And this would be November 6th of 2017.
Okay.
Then I think you also, you also testified about this meeting during your February 6th testimony. And Ms. Sloman had inferred from your testimony that you had essentially said that Director Niven had told you that you didn't have to go through a pre-application process. Is that true?
No, that's not accurate. So what happened in this meeting was that he acknowledged that the development agreement words did not require a pre-application, but that they were imposing it anyway. And so even though it was technically optional, that if we elected to skip it, that they would have no way of ever deeming our application complete because it would be like it was in a foreign language. So that was not an offer to skip the pre-app. That was a threat to, if you try to enforce your right to not have a pre-application meeting, I will never deem your application complete. That was the way I understood that communication.
Are you aware of any instances later after this November 6th meeting where the city was requiring pre-application meetings?
Yes, so I don't remember the exact date, but on our storage application, our consultant again asked if we could skip the pre-app and just go straight to submittal. And what the response that he got was Christopher Wright taking this email that is Keith's email in C50 and cutting and pasting it into an email to our consultant, Sean, and saying, here's your answer, and that we were required to do a pre-app. So we did. At that point in time, if we were not required to do a pre-app, there is no way I would have done one.
Did the fact that Ms. Sloman didn't cite a pre-app response as an item missing from the complete application checklist for your SDPs and ASDPs mean that the city wasn't actually requiring pre-apps?
No, the reason why she didn't cite those as, why she didn't cite lack of responses to pre-app comments as an item that was missing for our applications for SDP was because the city was so delinquent in getting us the notes from the pre-application meetings. So there was a lag of, I think, between 4 and 8 weeks, depending on the application, between the date when we had the meeting and the date when we received the notes. So we didn't wait for those notes, and we submitted. And she's right, she didn't cite that, but that did not by any means mean that she didn't require a pre-app.
So I'm getting close to the end of this. If you'll permit me to keep going, I think we can wrap it up. But it's 9:42, so it would be, I'd prefer to just keep going through in the hopes that I can wrap it up.
We prefer you keep going.
Wonderful, thank you. Tia, when was the first time that you heard that Jean Lynn was your planner?
The first time I heard Jean Lynn was my planner was, I believe, at our pre-app for our plat.
Okay. And did you hear that there was a change at any time after that?
The first I heard of that was in the context of this hearing, when Ms. Sloman said that at some point she had become the planner on all of our applications.
Is that strange that you wouldn't know who the planner was on your applications for that period of time?
That is very unusual. I have been in this business for a long time, and I ran a land development department for a public home builder, and I can't think of another example of a time when I or my project manager did not know who our planner was that was assigned to our application. If your planner changes, that is something a city normally would inform you of. So for us to find out months after the fact that the planner had changed, very unusual.
To your knowledge, was the city treating, in terms of assigning staff resources, was the city treating other applicants such as Polygon the same as Shelter in terms of devoting staff resources to the applications?
No, I understood from Polygon that their projects were removed from Ms. Lynn and reassigned to other planners so that they could be processed more quickly, and they referred to Ms. Lynn as the Costco planner.
Did you hear Director Niven's testimony that the city didn't process our applications in a timely manner because of staffing?
I did, and I did not find that to be accurate, particularly in light of the testimony and the chart offered by Ms. Sloman.
Was Shelter ever assigned its own project planners to, specialized project planners to help its projects through the process faster?
I'm not aware of anything being done to help us through a process faster. We had Ms. Lynn as our project planner on all of our projects, well, until some unknown date when Lucy took them over, but nothing that I'm aware of was done to speed up review of our projects.
Turning briefly to the mixed-use proposal, did you hear Ms. Sloman's testimony about the community meetings that were held for the mixed-use proposal?
I did.
Were you at those meetings?
I was at those meetings. Staff was not at those meetings, or at least they told us that they did not attend. We invited them to attend. They elected not to.
Was Ms. Sloman's recollection of the meetings accurate?
No, I think she offered 2 articles.
Yeah, and those are at exhibits C 62 and 63, if we want to turn to those. So looking specifically at these articles that Ms. Sloman testified about and introduced into the record, starting with C62, is there anything that, well, is it, for starters, this is a broad question, is that accurate in all of its completeness to you, or are there things in there that are not accurate?
So C62 is not accurate in that it refers to a proposal to build 2,500 residential units. That was a misunderstanding that some members of the public had after that meeting, because at our initial meeting, what we were sharing was not a proposal. We didn't have a map that showed uses or anything else. We were sharing market data and transportation analysis and other community analysis, some architecture concepts. We were seeking feedback on the types of uses. So the 2,500 units, residential units, was indicative of what the market forecast said that there was a market for on that property. We tried to be clear about that, but clearly, some people misunderstood it. I thought it was misleading for Ms. Sloman to offer this as if it were the proposal, because I thought that the city was quite clear, because we had lots of conversations with the city, that that was never our proposal. But again, this was all related to the mixed-use proposal, which has been off the table for a very long time. But this article in particular is not accurate.
In the section titled Many Moving Parts over there, it's on the right-hand side, kind of close to the photos on the page. It says, explains that the Issaquah Highlands was born with a 20-year development agreement signed on June 18, 1996. The actual, in quotations, expiration, end quotations, is in 2017. Is that accurate?
That also is not accurate. So as we've discussed at length, build-out period is separate and distinct from termination or expiration of the development agreement. So that part was also not accurate.
And then if you go to C63, the other article, did Ms. Sloman's testimony accurately characterize what this article actually says?
So my recollection is no. This article, I think, actually is relatively accurate. And if you look at the timing of it, it was from February of 2017. So this was written after we went back to the community. So we went in May and said, here's the data and tell us what you want. We came back in July and said, here's what we think we could do. Tell us what you think. Then we had focus groups in August, and then we went back to the city. They said they would never be supportive, so just do something that's allowed under the development agreement. And so I think it was January of 2017, we went back to the community because we felt like we had started this dialogue and we owed it to the community to fill them in on what had happened. And we explained that the city wasn't supportive of the mixed use, and so we were pursuing the commercial and retail uses under the development agreement, and that the first thing that they were going to see was a plat that we would be applying for shortly. So this article is written after that. I think the way that that Ms. Sloman characterized it was as if this article was showing the scale back from 2,500 units to 1,800 units, which isn't accurate. What this article actually demonstrates is that we were very public in our intent to pursue uses under the development agreement exactly as the city had instructed us to.
Did you hear the questions that Mr. Lell was asking of Mr. Mullaney regarding Rich Hill's statements given in a December 2017 meeting to the city?
I did.
Were you present at that meeting that Rich Hill was speaking at?
I was, and I thought that Rich Hill's testimony demonstrated that he did not understand the facts of how things are in Issaquah. So his description of what a pre-app is was consistent with what would be typical in other jurisdictions, and it was absolutely not consistent with what a pre-application or a preliminary land use application is in the city of Issaquah. So to me, his testimony or his comments that he offered were based on incorrect facts, and so they just weren't relevant in that respect. So when Mr. Mullaney said Rich's testimony was wrong, I think that is the primary thing that he's referring to, was if you assumed that a pre-app was an informal conversation, a sketch on the back of a napkin, and he was saying that those things shouldn't vest, that somebody shouldn't be able to vest by having a meeting where you just had a conversation. That's not what a preliminary land use application is in Issaquah.
Who did Rich Hill represent at that time?
He represented Regency Centers, which is the Grand Ridge Plaza owner, and he may have also been representing Safeway, I'm not entirely certain, which is the grocer that's up there. And both of those clients of his, or potential clients of his, were adamant that the city had promised them that there would be no additional retail in Issaquah Highlands, and that the city should do anything that they needed to do to block our proposal for retail.
I have no further questions.
Terrific. So I think due to the hour, it's probably not a convenient time to start, Mr. Lowell. What are your thoughts?
I would concur on that, Mr. Chairman, and I think, I'm not sure what we have scheduled tentatively for our next meeting, but my assumption is that I would be able to wrap up within
Well,
5 minutes or so.
given that we've basically reached the agreed time, that we will be continuing the public hearing on tonight's agenda to July 2nd. I understand that all the parties and commissioners will be available.
We never got a response.
So that's correct. And with that, the public...
With all due respect, we did exchange some emails with Ms. Sloman on this issue. As we've stated before, this process has been very, very long and caused a lot of damages for shelter. It's very expensive to go through this month after month, and it's a lot to put all of you through as well. We had suggested a couple of other dates of the 19th and the 24th, and we're told that there were some people available, but it's not clear who or whether there would still be a quorum available to make a decision on those dates. And just haven't, as far as I know, haven't received a response to that. So we were hoping to get some clarification on whether those dates might be sooner available dates for us rather than July 2nd.
As far as I know, the dates were selected by the number of people that could be here on those nights, and people weren't available.
Well, I think our concern is we specifically asked whether there would be a quorum and haven't received an answer. And if there would be a quorum, we would respectfully request that you go ahead, even if not everyone could be here.
I think we should let Ms. Sloman speak to it, because I don't know that you guys were even floated those days. I think there were other issues with room availability and the attorney's availability, but Lucy, do you want to speak to that?
She specifically said a commissioner.
So I had not received a question related to a quorum. I did identify that the 24th, we had a challenge with the meeting room. We were able to potentially identify an alternative meeting room, but not the availability of all 5 commissioners. I don't know whether the other 4 commissioners were available, because my understanding was that we were having all 5 commissioners present to debate based on the extent.
So obviously, our choice would be to have all the commissioners that have sat through this to be able to continuing the deliberation. At the same time, we understand the need for expedited conclusion of this process. So I guess I'll ask the commissioners if there's a consensus that we could try to modify that, go back and look for maybe a sooner date and decide we need 4 commissioners to have a quorum. And would you agree to proceeding with just a quorum as opposed to all being here?
I would not. I don't think it's fair to the commissioners who've sat up here for 8 months listening to this, hearing the same arguments over and over and over again, and then be told that because you want to expedite it, we're not going to have all 5 commissioners deliberate on this. I don't think that's fair at all. I wouldn't agree to it.
Okay.
I concur with that.
I concur as well. I think that all the perspectives on the commission are very valuable for this decision.
Okay. Well, the decision is that we'll proceed with the number of commissioners that we have, and it looks like July 2nd will be the date of the next meeting.
Thank you.
And we'll be in the council chambers at 6:30. We hope that we'll be able to conclude the hearing on that night, and with that, tonight's meeting is adjourned.
Thank you.